afternoon, everyone, or I guess depending on where you are, it might also be morning. We want to thank you for joining today's webinar on the impacts of artificial intelligence in the workplace. So as I mentioned, I am Ashley Mitchell, and I am an attorney for Conn Maciel Carey based in our Chicago office. I practice in both our workplace safety group as well as our labor and employment group. I do a lot of advice and counseling as it relates to Title VII and ADA issues, and specifically as it relates to today's webinar. I am a part of Conn Maciel Carey's working group on just thinking through AIs as it relates to employment. I actually did a blog post just recently on the EEOC's update to its Title VII and AI guidance, and I'm looking forward to giving you some more detail about that this afternoon. Darius?
Hi, everyone. My name is Darius. I'm also an associate here. I work at the Washington, D.C. office of Conn Maciel Carey. I support both the labor and employment and OSHA practice groups. I'm very excited to chat about our topic today, the artificial intelligence, because I think what's really interesting about it, and I think you'll kind of get the flavor of it as we go through the presentation, is that really it touches on most everything sort of listed on this bio slide. So it is really interesting. It's a good thing to think about further moving forward. So we hope you enjoy it. And please, if you have any questions during it, don't hesitate to drop them in the chat. We'll be happy to do our best to answer them.
Thanks, Darius. So just a brief overview of our agenda. First and foremost, we're going to start off by giving you an overview of AI. I know that term artificial intelligence is used a lot, so we'll give you an overview of what specifically we're referring to during today's webinar. We will then turn to explore the regulatory framework, kind of the guidance that's already out there, what we are looking forward to seeing in the near future, and the laws that already are in place, regulating the use of this in the workplace. And then we'll give some examples of how AI is currently being used. And then finally, we will close out our webinar today with some tips for developing a strategy that's right for your company and how you can prevent the misuse of AI within your company. And with that, I'll turn it over to Darius for the overview of AI.
So a good starting place for presentation on artificial intelligence is to try and explain exactly what it is that we're going to be talking about. So broadly, sort of from a definitional sense, AI it's a branch of computer science. It's kind of deals with the simulation of intelligent behavior in computers. Really, the premise of artificial intelligence came back from like the 1980s, and the idea was to see whether people could program a computer with the right inputs and outputs, have the same sort of sense that human beings have in terms of can you simulate a mind? Would it be technologically feasible to sort of copy the brain into hardware and software, making a simulation that would be identical to the original? In terms of how it's defined by Congress, it means a machine-based system that can, given a human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. Obviously, this is quite like sounds like a pretty intense undertaking. So what we'll do throughout the presentation is sort of explain how that kind of sort of premise, that sort of idea is really applied in kind of the employment law context. There are, and this is, I think, more background for your information. I think there's kind of two different, there's two types of AI that you'll probably have been familiar with. There's one, machine learning, and there's two, deep learning. Machine learning, it's kind of the best example for machine learning is it's sort of like your music service that will make a decision about which new songs or artists to recommend to a listener. The machine learning algorithm basically associates a listener's preferences with other listeners who have similar musical tastes. And that sort of technique of the association from one listener to another is sort of touted as AI. And it's offered in, a lot of sort of services that have automated recommendations. A subset of machine learning is called deep learning. And the goal of deep learning is a concept you might have heard of called nonlinear learning, which is the idea where a tool can perform tasks without that sort of specific explicit programming from machine learning, where machine learning is sort of saying, can you apply one person's music taste to another? Deep learning tries to mimic how the brain works. It's given lots and lots of raw data, and it's supposed to decide for itself what features are relevant and will sometimes improve as you sort of increase the amount of data being used to train it. So in terms of how AI works broadly, and I think this is important sort of for your knowledge from a human resources perspective, is AI models accept inputs and return outputs. They'll sort of analyze data sets to find patterns and make predictions and decisions. So what we're concerned with today is really kind of like the inputs and the outputs. Is that one, sort of what information is being inputted and what kind of output is that output can be something that can cause you any liability, or could it on a basic level cause you outputs that aren't exactly what you wanted it to provide to you, but the artificial intelligence decided differently. The most sort of famous or well-known type of generative AI is called ChatGPT. It's sort of a large language model based chatbot. And the idea is that it'll sort of generate human-like responses to chat requests. It's used for a lot of things, but basically, some of the uses are brainstorming, content creation, language translation. It can be a virtual personal assistant. It can, answer general inquiries, really anything you need text for. Because what these large language models are is they're sort of trained on these massive data sets to recognize, translate, predict, and then generate text. The other kind of interesting thing about ChatGPT, from more of an employment perspective, is that it's been in the news a lot the last couple of days. And that's because ChatGPT is owned by a company called OpenAI. OpenAI is really interesting in that recently they fired their founder, and their founder was a very valuable person, well known in the artificial intelligence space. And the board made what seems to be a mistake in that they didn't take a sort of an appropriate temperature of their employees. Because now, from what I understand from reading the news, is that a lot of their employees are right now considering whether to leave this company. And obviously, look, if it were not ChatGPT stroke OpenAI, it's unlikely we would be, sort of doing this presentation today. So obviously, this is very valuable, very influential software. And right now, the board's in a position where, because they didn't take into account employee morale, which is, well, not illegal, sort of not an advisable decision from a labor and employment perspective, they're at the risk of losing sort of one of the more valuable companies that I can think of on the top of my head. And like I said, we wouldn't be doing this presentation more than likely were it not for the creation of ChatGPT. Actually, I don't know if there's anything else you want to talk about on this.
Thanks, Darius. So as Darius mentioned, just in recent developments honestly, since Friday, when OpenAI announced that they were terminating Sam Altman, their founder and CEO, there have been a ton of developments in this space. Specifically, as Darius mentioned, several other leaders of the company have resigned in solidarity. And it is also the case now that the news outlets are reporting that roughly 700 of the less than 800 OpenAI employees have also threatened to resign in solidarity with Sam Altman. And so in thinking about this in a broader labor and employment context, and just in a broader context of where we are in the labor movement, certainly would have been more advisable for the board to take into consideration employee morale, stability within the company. It was certainly unexpected that Mr. Altman was terminated on Friday, and then the board seemed to waver on whether or not they were going to bring Mr. Altman back, him being on the property on Sunday as a guest, and then the board doubling down on its decision to terminate Mr. Altman's employment, and then sort of one of the leaders of the coup posting to X, which is formerly known as Twitter, an apology for, leading the charge to terminate Mr. Altman. And so when you think about this in the broader labor context, you can't help but think through, perhaps it's not the case that other employees might resign in solidarity, but it's certainly the case that these kinds of brash moves or these kind of unexpected announcements lead to labor organizing, which we've seen a really big year around the push for organized labor, the push for unions, and how that has trickled down to other workplaces. And so definitely something that we're keeping an eye on over here at CMC.
Yeah, it's a quick detour in the labor and employment world, but certainly a really interesting one given ChatGPT. Actually, I'll let you go into the regulatory framework from here.
Thank you. So just briefly, countries worldwide are designing and implementing AI governance legislation that is commensurate to the head-spinning velocity and variety of the proliferating AI-powered technologies. These legislative efforts include the development of comprehensive legislation, focused legislations for specific use cases, as well as voluntary guidelines and standards. And so on the next slide, I will be talking about the EEOC guidance. So earlier this year, the EEOC issued guidance meant to address whether and how to monitor new algorithmic decision-making tools and employment selection procedures. And so just some examples of those algorithmic decision-making tools. For example, you have resume scanners that prioritize applicants which use predetermined keywords. You have employee monitoring software that can rate employees on the basis of their output, virtual assistants or chatbots that ask job candidates about their qualifications and reject those who do not meet predefined requirements. There's video interviewing software that can evaluate a candidate based on their facial expressions and speech patterns. And last but certainly not least, there's also testing software that provides job fit scores for applicants or employees regarding their personalities, aptitudes, cognitive skills, or their perceived cultural fit based on their performance on a game or a more traditional test. Now, this year's guidance refers employers to the EEOC's 1978 Uniform Guidelines on Employee Selection Procedures, or guidelines for short. Although these guidelines predate AI, certainly they're from last century, this year's EEOC guidance makes it clear that selection procedures are, quote, any measure, combination of measures, or procedure that are used as the basis for an employment decision, and therefore those guidelines would apply to AI. Now, these guidelines provide guidance for employers about how to determine whether their test and other selection procedures that are used as a basis for employment decisions create a disparate impact and violation of Title VII. Employment decisions include, but are not limited to, hiring, promoting, and demoting. And then just briefly, disparate impact occurs when a seemingly neutral test or selection criteria disproportionately excludes individuals based on a protected category. Now, as a general rule of thumb, employers may rely on the 4/5 rule in determining whether the selection procedure creates a disparate impact. Under that 4/5 rule, a selection rate for any protected category that is less than 4/5 or 80% of the selection rate for the group with the highest selection rate would generally be regarded as disparate impact. So the guidance provides the following example. In a personality test scored by an algorithm, the selection rate for applicants was 30%, and the selection rate for white applicants was 60%. The ratio of the two rates is thus 30-60 or 50%. Because 50% is lower than 4/5, which is 80%, the 4/5 rule says that the selection rate for the Black applicants is substantially different than the selection rate for white applicants in this example, which could be evidence of discrimination against Black applicants. Now, it's worth noting that compliance with the 4/5 rule is just a general rule of thumb and does not guarantee that a selection procedure does not have an adverse impact for purposes of Title VII. That being said, if an employer determines that the selection procedure does have an adverse impact, the employer must determine whether the selection procedure is, quote, job-related and consistent with business necessity. Employers must also consider whether there is a suitable alternative selection procedure. And so here, especially as it relates to the development and use of AI, where there is an alternative selection procedure that will serve the same purpose, but eliminates the disparate impact, employers should use the selection procedure that eliminates disparate impact. And on the next slide, we give an example of one of the very first cases in this area as it relates to the use of AI in employment selection procedures. So last year, the EEOC filed a lawsuit against the iTutor group. And just briefly, iTutor is an organization that hires remote English tutors for students in China. The EEOC brought this lawsuit, and the lawsuit alleged that iTutor's hiring and selection procedures unlawfully discriminated against applicants on the basis of their age. Now, that lawsuit was recently settled, and under the settlement, iTutor agreed to pay $365,000 to a group of applicants whose applications had been rejected because of their age. And then the company also agreed to submit to the EEOC proposed anti-discrimination and complaint procedures applicable to the screening, hiring, and supervision of candidates and employees. So we can see that the EEOC has not only released guidance, there's Title VII guidance, there's disability guidance. We can see that the EEOC has not only released guidance, but they are now actively starting to pursue litigation and lawsuits as it relates to the use of AI in employment decisions. And later in today's webinar, we will give you some tips and tools for how you should be thinking about employing the use of AI. But for now, we're going to turn to the current state of AI laws. Of the AI-related laws that went into effect this year, most of them are part of a comprehensive consumer privacy law. These sorts of laws regulate AI and automated decision-making by allowing the users to opt out of profiling and requiring impact assessments. But one law that stands out specifically comes from New York City, as this law directly regulates employers' use of AI in the hiring and recruitment process. And so New York City Local Law 144 regulates the use of automated employment decision tools. Under the law, automated employment decision tools are any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation that is used to substantially assist or replace discretionary decision-making for making employment decisions that impacts natural persons. That's a mouthful. Essentially, the law is designed to target any kind of AI that is used to assist in making employment decisions. Think hiring, firing, recruiting, think RIFs, or any sort of AI that generates data that is going to be used to support those employment making decisions. And so under Local Law 144, employers or employment agencies that use an automated employment decision tool to screen a candidate or an existing employee for an employment decision must conduct a bias audit no more than 1 year before using the tool, make the results of the most recent bias audit publicly available on the employer or employment agency's website before using the tool, and notify each candidate or employee who applied for the position of the following. These are that an automated employment decision tool will be used in connection with the evaluation of the employee or candidate, the job qualifications and characteristics that the automated employment decision tool will use, the assessment of the employee or candidate, and finally, information about the type of data collected for this automated decision tool, the source of such data, and the employer or employment agency's data retention policy. So a really big law out of New York City that requires not only some front-facing disclosures, but also some back-end data and retention policies. On the next couple of slides, we look at proposed bills regulating AI in employment settings. So several states have proposed bills that guard against the general harms of AI. These AI bills express concern for discrimination resulting from AI use. Think more cases like iTutor, where employers are using AI tools to screen candidates or to screen job applicants. And the AI tool or software is discriminating against or excluding individuals on the basis of a protected category like age, race, or gender. And then there are some bills that are more concerned about harms within specific industries like hiring, healthcare, voting, or insurance. So following in the footsteps of New York City, several states have proposed bills regulating AI use in employment settings, and these are often around making hiring decisions. And so we can see some examples here. For example, Massachusetts introduced a bill. I'm sorry, let me go back one more slide.
Are we there now?
Massachusetts introduced a bill that would require employers to provide employees with notice about algorithmic decisions and monitoring. And it would also give employees the right to request information that's being processed through the algorithm. New York State has a couple of bills. One that would amend the labor law to include criteria for automated decision-making tools. And it would also require a separate and distinct disparate impact analysis. And then another New York State law that would require employees to give notice to candidates if they use automated decision tools to make employment decisions. And then on our final slide about proposed bills regulating generative AI, we are keeping an eye out again on those Massachusetts and New York states. In Massachusetts, we've seen a bill that would prohibit bias in generative AI models and would require safeguards against plagiarism and consumer privacy protections for those using generative AI, as well as registration with the Attorney General. I know I've said a mouthful. We will go into greater detail about safeguards against plagiarism and consumer privacy protections later in today's webinar. And then we've seen some more bills out of New York, requiring political communications, for example, to disclose the use of synthetic media, or, a bill that would prevent film production companies from receiving production credit from using AI to replace actors in their productions, although I'm not sure that this one will gain a lot of traction given the recent union agreement reached between SAG-AFTRA and the Writer and Actors Guild. And with that, I will turn it back over to Darius. Am I turning it back to you, Darius, or is there one more here? Oh, there is one more here. As it relates to the current state of U.S. federal law, it is important to note that there has not been any major legislative movement in Congress, although earlier this year there were congressional hearings about the responsible use and development of AI. Notably, then OpenAI CEO Sam Altman testified as part of the congressional hearings. Despite the lack of movement in Congress, just a few weeks ago, President Biden signed the Safe, Secure, and Trustworthy Development and Use of Artificial Intelligence Executive Order. And then what's notable here for employers is that the executive order directs the Secretary of Labor to publish principles and best practices for employers that could mitigate AI's potential harms to employees while maximizing its benefits. Now, we've also seen some other regulatory action. In the fall of last year, the White House Office of Science and Technology Policy issued its AI Bill of Rights, which identified 5 principles that should guide the design, use, and deployment of automated systems with the goal of protecting the American public. As I go through each of these 5 principles, I am certain that we will dive into them in greater detail later. But the first one is safe and effective systems, which essentially means that these AI tools should be and automated systems should be developed in consultation with diverse communities, stakeholders, and domain experts to identify potential concerns, risks, and impacts of the system. Importantly, the Bill of Rights suggests that systems undergo pre-deployment testing, risk identification and mitigation, and ongoing monitoring that demonstrate the system is safe and effective based on its intended use. The second principle out of the AI Bill of Rights relates to a logarithmic discrimination procedures. And here, designers, developers, and users of automated systems should be proactive and make continuing efforts to protect individuals and communities from a logarithmic discrimination on the basis of their protected categories. So here we're thinking race, color, ethnicity, sex, especially including sex as it relates to pregnancy, childbirth and related medical conditions. We are also thinking religion, age, national origin, disability. And here we're also thinking about including ensuring accessibility for people with disabilities in the design of the AI software itself. And then I've named a few, but of course, any other category that may be protected by law. The third principle to come out of that AI Bill of Rights is data privacy, which suggests built-in data protections that only collect data and information that is reasonable and request a user's permission before collecting and using their data. Fourth is a notice and explanation, which would inform users that an automated system is being used and provide plain language for users to understand how the automated system contributes to outcome and its impact on users. And fifth and finally are human alternatives, considerations, and fallbacks. So we're here thinking about permitting users to opt out where it may be appropriate and providing users access to a person who can quickly consider and remedy any issues that may be experienced by the user. And with that, I turn it over to Darius to give examples of how AI is used in the workplace.
Thank you. So my thought here is I'm going to give, my intention here is to give some examples of how AI is used in the workplace. And my thought is that it'll probably be helpful to sort of the human resources / business professional listening in, because I think it'll be helpful to one sort of issue spot how sort of the regulatory framework that Ashley just indicated might apply to your company now, but also like perhaps in the future, so that you can find out how you're using AI like presently, or how, you know, as AI becomes more accessible and sort of useful to your company, it can be used, and how you can sort of balance that against potential risk of liability. So we'll start kind of at the beginning of the employment cycle using AI to recruit. There's a number of ways it can be used, but I think the most common one, which actually touched on earlier on, was sort of screening software that might automate resume screening by using AI to sort of scan resume databases. The scanning part isn't where the actual AI is going to come in. It's going to start analyzing those resumes that it reviews. And what it would do is sort of look at, you know, sort of which candidates might typically be successful at your company's presently at your company based on their performance, tenure, and turnover rates. And it might also learn what existing employees' experiences, skills, and other qualities are, and then apply this knowledge to new applicants in order to sort of rank, grade, and shortlist to the strongest candidates. It could also be used to sort of scan sort of public data sources to look into prior employers, as well as kind of individuals' public social media profiles while they are applying for jobs. And I think in the most sort of common way, it's used in chatbots to kind of engage with candidates during their onboarding in a way that might be sort of like less disruptive to your company's workflow, the candidate's workflow, and also sort of require sort of less HR support than might be required otherwise. One of the sort of the more time-consuming parts of some of human resources work can be drafting written materials, and kind of like we spoke about previously on in terms of the introduction on AI, one way that AI can be used is to draft written materials like job descriptions, performance reviews, and marketing materials. AI is also interestingly pretty prevalent in sort of its use towards managing employee performance. So as well as sort of recruiting and hiring, algorithms can be used to manage the performance of employees. I think this really sort of started to uptick during the COVID-19 pandemic, as sort of more employees were working remotely, which gave employers more of an opportunity to implement these tools. So examples of some of the tools that the companies can use presently or might be using more in the future are tools that might track the characters typed on an employee's keyboard, monitor whether an employee is paying attention to their computer screens by using webcams or even eye tracking software, which would have its own privacy implications. You can surveil websites and applications used by employees and track how long employees spend on various tasks. Similarly, algorithms are also capable of kind of identifying when employees spend too much time off task and potentially generating disciplinary recommendations based thereupon. And otherwise, employees who might not meet performance metrics could also be subject to formal discipline, including termination of employment at the recommendation of an AI algorithm. So while some algorithms at present, might only make suggestions regarding sort of providing warnings or terminating employees, others are actually programmed to formally discipline employees entirely on their own, and in some cases to generate termination notices. Obviously, that's alarming. You can see how it would be useful to sort of a large employer which has a massive workforce to sort of manage. And then one of the more interesting ways that some algorithms can be used is actually in the employee retention sphere, whereas there are algorithms that can analyze patterns of conduct to predict when an employee might be likely to quit, which is useful for an employer if they want to sort of intervene and sort of prevent or sort of incentivize that employee to stay and kind of allow companies to take action to retain critical talent when they're sort of being alarmed by some sort of AI software that an employee might be likely to quit based on any number of reasons that AI could pick up on, such as workflow, disengaging, anything they might pick up on that demonstrates the employee is no longer 100% all in. So in terms of another way that AI could be useful is sort of to manage employee compensation. Again, this is something where it's going to be really helpful in sort of a larger workforce, right? Where AI could be used to help companies use analytics to identify, employee challenges and predict trends in compensation. And so it gives employers the opportunity to address employee needs and really optimize compensation and incentives, sort of really result and target higher employee engagement. But it's also important because it can make and sort of most importantly make compensation more fair. It allows employers to make rules that are difficult to break, where because an algorithm will be managing them, or sort of ensuring that they're implemented appropriately, making sure that employees are compensated fairly based on things like their experience, their certifications, what they bring to businesses, and allow businesses to really move closer to closing pay gaps that might be there otherwise. Another way that I thought was really interesting that some AI tools can sort of be used is to shape employee career paths. AI tools can be used to match employees to like internal projects at companies by analyzing their skills and interests. The premise would be to create a sort of marketplace where internal projects might be advertised, and then algorithms could match employees to individual projects based on their capabilities, interests, and sort of project needs. The idea being, an employer might be able to save costs by keeping assignments in externally, and they're also sort of advertised as a way to increase employee satisfaction by permitting employees to use the full range of their skills, even if it means sort of venturing kind of temporarily even outside of their regular unit. I will let Ashley jump in here and sort of explain how, in using these tools, it's important to be careful and really conscious about how you sort of develop your AI strategy to make sure you don't sort of run afoul of any of that regulatory framework or result in unintended consequences.
Thanks, Darius. So yes, as Darius pointed out, now that we have a general understanding of what AI is, the regulatory framework and how AI is used in various workplaces, let's talk about how we can develop an AI strategy for your workplace. So on our first slide here, we have just kind of three. I'm sorry, Darius, can you go to our next slide?
Sorry about that, my computer froze.
Thank you. Looks like our tech is already checking out early for the holidays. But here on our first slide, we just have kind of three main points for developing an organizational AI strategy. The first being written policies and guidance. And so as a preliminary matter, to the extent that AI is going to be deployed in your workplace, or that you don't want employees using AI in your workplace, you should develop a formal policy on the permitted and prohibited uses of AI. Now, before undertaking to write this policy, it's imperative that you understand not just the nature of your work, but also any legal or professional rules that govern your daily work. So you may consider, for example, whether your industry is required to maintain data and information in a confidential manner. After you've got that full understanding of the nature of your work and the professional and legal obligations, it's important to fully understand the benefits and limitations of the kind of AI you may want to implement in your workplace, as all of these things will have an impact on the policies that you develop. Second is training. After, all of the policies and guidance are developed and implemented, it is important to train employees on the policies so that they understand the permitted and prohibited uses of AI within the workplace, and just so that they have a general understanding of what is expected to them, what is expected of them in this ever-evolving field. And then finally, auditing and monitoring. So we've talked about New York Law 144, which requires auditing, and as suggested by almost all AI guidance and framework, it's important to regularly audit the performance of AI. And so you may think of this similar to conducting an employee performance review. In the same way that you audit an employee's performance to determine if they are meeting company expectations and working up to your company values, you will similarly want to routinely audit AI to ensure that it is working effectively and its outputs are generally in line with company values and not running afoul of federal and local laws. And so on the next slide, we have our first tip for developing an organizational AI strategy. And we're going to dive a little bit more into the specific elements of the AI policy in and of itself. And so when drafting the AI policy, it's important to really think through and define the purpose and scope of the policy. This last year has taught us that AI is being developed and implemented faster than regulations related to the responsible use of AI can even be drafted. And so a strong purpose statement will determine those foundational guiding principles of the use of AI in your workplace in a rapidly changing landscape. So some things you may consider when developing the purpose statement are whether AI is helpful to your organization, the potential uses and misuses of AI within your org, and the potential benefits and risks of using AI. All of these tie into our opening discussion about whether your industry is bound by legal or professional rules that govern your work, as well as the maintenance and disclosure of potential confidential information. Our second tip for developing an organizational AI strategy is that after you have defined the purpose and scope, you can work to develop general principles that align with that purpose and scope. So here you can think of these principles as a set of rules that outline the permitted and prohibited uses of AI. While you might include some bright line rules, such as employees are not permitted to use ChatGPT, you may also consider incorporating rules that are more general in nature, such as employees are not permitted to use the work product of large language models without due diligence, including independently confirming the accuracy of the information presented and independently confirming the legitimacy of each of the cited sources. I've said a lot here, so I will pause and try to break that down just a little bit. The reason I'm making this distinction between bright line rules, such as you can or you cannot use ChatGPT, and more general rules as it relates to large language models, a large language model being any sort of AI where you can type a question and it generates an answer in a written paragraph, methodical sort of explanation and analysis, is because, this last year has showed us that the tech is ever evolving. And so while you might have some bright line rules about ChatGPT or DALL-E, which is the artistic equivalent of ChatGPT, you may also want to consider rules that moderate or regulate the use of the type of AI so that if ChatGPT becomes extinct, your policy is not extinct and you are not back at the drawing board. So you want to, in setting up these principles, you're going to want to think about your purpose and scope, and develop principles both very narrow as it relates to the tech we have now and broad as it relates to the capabilities of the tech, to incorporate into your company's written policy and guidelines. Now, our third tip is no surprise because we have discussed data privacy a lot today. And so our third tip focuses on protecting sensitive data. Some generative AI tools are cloud-based or software as a service, which means that the data is being sent to a third-party service provider. And so if a company provides confidential information to these third-party platforms, and the information is then fed back into the AI model for training purposes, a company could lose trade secret protection for that information. So in developing an AI strategy, it is really important to understand what data privacy guardrails are in place for any iteration of AI that you are considering implementing. And as you think about guiding principles, which we discussed on the prior slide, you may consider that as a general principle, your company will not use AI that does not readily disclose what happens to the data input or how the data is maintained and stored. Our fourth tip relates to quality control. So as you consider the potential uses for AI, you absolutely should consider the reliability of the AI that you might be using. So as an example, earlier this year, a lawyer used ChatGPT to help him write a brief. And as part of that brief, ChatGPT cited 2 cases and represented A, that those cases were real, and B, that those cases were precedential. Now, it turns out that ChatGPT made a false representation and those cases were not real. ChatGPT just kind of made them up out of thin air. And so not only did those cases not exist, but they absolutely were not precedent that the court could rely on in making a decision on the attorney's motion. Now, that lawyer was subject to sanctions for misrepresenting that he had actually written the brief and confirmed that the cases were in fact real and precedential. This example is one of the ways that we like to think about quality control. And so when you're thinking about the potential use of AI in your workplace, you will want to consider whether the technology that you're going to be deploying is reliable. But the analysis doesn't stop there because you're going to also want to implement checks and balances. So if, for example, you are using AI to screen 1,000 resumes, you may not read all 1,000 resumes, but you may consider performing an audit using the EEOC's 4/5 rule to determine if the AI is discriminating in a way that violates federal and local laws. The bottom line is that while employees may rely on an AI's output, employees should absolutely apply their expertise and exercise sound judgment on how best to use the output. And then our fifth and final tip for developing an organizational AI strategy is to preserve authenticity and avoid misrepresentations. And so here it's really important to be open and honest about the use of AI. As we saw in the New York law, there are disclosure requirements. And in general, we've seen a lot of guidance suggesting that transparency is key when using AI tools. And so you're going to want to let anyone know who is being affected or evaluated by this AI tool that they are, in fact, being evaluated by the AI and the role that AI is playing in their individual evaluation. You know, social media is notorious for calling out content that was created using generative AI. And so you're going to want to make sure that you are being open and honest with those individuals who are going to be impacted by AI and let them know we're using AI. This is how we're using it. This is what happens to your data input. This is how we're storing and maintaining the data. And this is how we as an organization are checking to ensure that or auditing to ensure that our AI aligns with our company values. And with that, I will turn it to Darius for how HR can prevent the misuse of AI.
So we have a few tips on how HR can really be involved to prevent the misuse of AI. I think the first one's a good place to start, and it's, start small, right? I gave up a long list of sort of tasks that you could use AI for. But I think on a fundamental level, it's really important not to rush in without adequate preparation. I think, a good example would be maybe you don't want to start by sort of automating your entire compensation structure. Maybe things like discrete tasks, drafting job descriptions, scanning resumes, are a good starting place so you can get the hang of sort of analyzing AI software, making sure it's doing what you want it to do, and most importantly, not giving you sort of the negative outputs that could, one, cause you liability, or two, on a more simple level, just be unfair. So you'll get practice, you'll learn more as sort of the software comes out, as there becomes more regulation, as the software sort of improves, like as it tends to improve quite quickly. It's important just to analyze software you use to make sure it doesn't violate the laws, result in unintended consequences for your business. Point being, start small, be careful, no reason to jump in unnecessarily. The second tip, and this is just understand how AI can affect individuals with disabilities. In sort of doing a lot of research to prepare for this, one of the things that really came about is that AI does have like a very high potential to sort of result in algorithmic decision making that might affect individuals with disabilities. With that in mind, I mean, last May, the EEOC and DOJ were sort of the first federal agencies to really publish guidance addressing disability discrimination in automated hiring assessments, which are used by major employers for a lot of reasons, but mostly because it's an easier way to sort of assess candidates quickly and at a high rate. The goal of sort of that document was really to discuss how existing ADA requirements can apply to the use of AI and employment-related decision-making, and really offer sort of, some sort of practices that employers can follow to help with ADA compliance when using AI decision-making tools. It was the very first guidance document the EEOC issued since its like sort of initial AI initiative that was announced in October 2021. But really, there were sort of three sort of main ways that I think in reviewing that guidance document that jumped out as ways that AI could be a potential hook for liability based on discrimination based on disabilities. The first one is sort of if an employer doesn't provide a reasonable accommodation that is necessary for a job applicant or employee to kind of be rated fairly and accurately by an algorithm. The second is if an employer relies on an algorithmic decision-making tool that intentionally or unintentionally screens out an individual with a disability, even though that individual is able to do that job with a reasonable accommodation. A screen out would usually occur when a disability sort of prevents a job applicant or employee from meeting or even lowers their performance on a selection criteria, and the applicant or employee loses that job opportunity as a result. The disability could have taken could have caused this effect by sort of reducing the accuracy of the assessment, creating special circumstances that might not have been taken into account, or preventing the individual from participating in the assessment altogether. A common cause for this is sometimes if an individual or if an employer rather uses an AI tool that just hasn't been tested on individuals with disabilities. So it's not used to seeing individuals with disabilities until it's actually used in practice, and then start screening out individuals based on that. finally, the third way that it could sort of that use of algorithmic decision-making tools could violate the ADA is if the employer sort of adopts an algorithmic decision-making tool for use with its job applicants or employees that violates the ADA's restrictions on disability-related inquiries and medical examinations. Sort of, if your chatbot starts asking inappropriate questions or asking for medical examinations that are inappropriate and violate the ADA. The third tip that we thought was important to mention is just, in using HR, it's really important to, and this kind of tails off with the second tip, inform prospective employers that they are being assessed by an AI tool. One, I think that's going to be mandated by many laws, but two, it's really important to kind of inform all job applicants and employees of the potential sort of accommodations that are available, describe the purpose of the algorithm, and just make sure that the sort of employers are aware of and can explain the traits that the algorithm is designed to assess, the method by which those traits are assessed, and like the variables or factors that might affect the rating, so individuals can be aware of it moving forward. Actually, I'll let you talk about the AI policy if you'd like.
Thank you. Yes. Fourth, is carefully drafting a comprehensive AI policy. So I know we've talked a lot about the potential benefits and risk of the use of AI and the importance of drafting a comprehensive policy, but how do you go about the actual drafting? Well, as suggested in most of the guidance that we've covered, you are going to want to create a working group made up of diverse stakeholders who will be using the AI and potentially impacted by the use of AI. And you will want them to lead the AI policy development process. So this group will oversee the creation of the policy, research the necessary expertise, and they will ensure representation from various departments and stakeholders. Another tip is to educate those folks who are going to be a part of your working group. Make sure that they have a foundational understanding of AI and its ethical implications. Make sure that they have training sessions and workshops to familiarize themselves with essential AI concepts such as a logarithmic bias, privacy concerns, and AI's potential impact on employment. You're going to want to define the policy objectives. So you're going to start again by identifying those primary objectives and adopting AI technology. And these are the objectives that will shape the overall direction of the policy. These objectives may include improving your company's efficiency, enhancing customer experience, or promoting innovation. Fourth, you're going to really assess those principles and values, and you're going to determine the ethical principles and values that are going to guide your AI development and are going to guide the deployment of AI within your organization. You might consider things like fairness, transparency, accountability, human well-being concepts, all of which we've discussed, or most of which we've discussed, are certainly great starting points for ethical principles and values. You're also going to want to consult any regulations for your industry in particular, for individual employees, as well as your federal and state legal obligations, and include those in your ethical principles and values, as well as evaluate your legal regulatory compliance. And so just understanding the regulatory landscape that you are subject to right now, not just your professional obligations, but data protection laws, privacy regulations, industry-specific guidelines. I know here in the state of Illinois, where I am located, for example, we have the Biometric Information Privacy Act, which regulates the collection of biometric information. And so depending on the types of data that you are collecting, you are going to want to make sure that you are aware of sort of those legal obligations that are attached to the data and information. If you're installing a new time clock that relies on an employee hand scan, you're going to want to make sure that before you install that time clock, you are fully aware of any biometric laws that might apply to the use of that time clock. Additionally, when crafting your policy, you're going to want to identify potential AI use cases and risks, meaning you're going to want to identify the specific applications of AI within your organization, where it will be used, who will use it, and for what purpose. And then once you determine that, you're going to want to associate the risk associated with use. We've talked a lot about bias, but there are also security vulnerabilities and other unintended consequences. And once you have a good working list of those biases and vulnerabilities, you're going to want to develop guidelines and best practices to mitigate these risks. You're going to want to establish accountability and governance. Who will ultimately be responsible for your AI policy? You're going to want to define the roles and responsibilities of those stakeholders that are involved in the development, deployment, and monitoring so that you have clear lines of accountability and governance mechanisms to ensure that you are following your ethical values that you've identified, as well as any legal obligations. We've talked a lot about transparency and explainability. You're going to want to use clear documentation and plain language as you are crafting your policy, so that your employees and anyone who's affected by it can really understand what it is that they're reading, what the responsible data practices are, and understand how the use of a logarithm is affecting them. And then you're going to want to encourage continuous monitoring and evaluation in your policy. Now, I know we got a question from one of our participants, and the question was regarding auditing AI-driven programs. Will the fact that algorithms keep updating and learning make it harder for auditors to look under the hood, so to speak, and review the coding? And here, when we're talking about monitoring and evaluating, it's not so much the coding that we are thinking about, and more the outcomes of the data that's being input into the AI software. So for example, if you are using AI software to review resumes, it's not so much the coding that we're thinking about as much as it is, what is the outcome of that resume scanner? Is it disproportionately excluding a group of applicants because of their age or because of their race? And so what you will find is, in doing your audit, you will look at the demographics of all the folks who are applying for the job and the demographics of folks who are selected for the next step in the application process. And here's where that EEOC 4/5 rules comes into play. And so when we're talking about monitoring and evaluating, it's not so much, can you read code? Do you understand script? As much as it is being able to have a metric whereby you evaluate the impact or you evaluate the data output. This goes as well for large language model AI, where you are feeding it a question, it's generating an answer, and you are using, human review to evaluate that answer. Is the answer accurate? Are the sources cited legitimate and real? Doing that fact checking step. And that's what we mean when we say continuous monitoring and evaluation. And then last but not least, as you're carefully crafting your comprehensive AI policy, you're going to want to communicate that policy. You're going to want to a document that encompasses all of the elements. It's clearly written down in accessible language and provides practical guidance to employees. For some folks, this is going to be new information, and so you're going to want to provide it in a way that's approachable and easy to understand. A lot of guidance that already exists provides examples, and so that might be one thing that your working group considers, including in the actual written policy, real life examples that apply to your workplace and your organization. And then finally, as no surprise, you will want to continually train your employees on your policies, your guidance, and the use the permitted and prohibited use of AI in the workplace. You know, it's great if you have this wonderful and diverse working group full of stakeholders, and you've identified your guiding purpose, you have these wonderful written policies, but if you don't actually train your employees on the policies and give them an opportunity to ask questions to ensure that they really understand, there's still a risk for misuse or prohibited use of AI. And so you're going to want to make sure that you are doing a lot of training and really explaining to employees what AI is as it relates to your workplace, how they are permitted to use AI, the prohibited uses of AI, and potentially you might want to consider, you know, explaining why, for example, they might not be allowed to use ChatGPT or Dolly. You know, you're also going to want to educate your HR staff on all the components of any AI tool that is being used and how to handle individuals with disabilities. And so we spent a lot of time talking about the folks who are using the AI tool. Some of those folks might require an accommodation or an alternative means to apply for the job because the AI is incompatible with maybe their screen reader, or they are unable to, for example, emote in a way that is compatible with the pre-video screening. And so you're going to want to work with HR and train them on how to recognize requests for accommodations in this new landscape and what potential alternative means of rating job applicants might be, and sort of being proactive again with the folks who are doing your coding to make sure that your software is as accessible as possible. And with that, I know that we are at time, but I will go ahead and close us out by pointing you to our 2023 webinar series. We do have one more webinar this year for the NLRB and joint employer updates. This one promises to be exciting as we've seen a lot of movement at the board as it relates to union organizing, as it relates to permissible practices and employee handbooks. So you certainly don't want to miss that. And then also just pointing you to each of our blogs. As Darius and I both mentioned, we do expect some movement within this area. There's some legislation that we are watching, as well as a result of Biden's executive order, we are expecting some best practices from the Department of Labor. And so we will certainly be keeping a watchful eye and updating each of our blogs. So please make sure to check those out. As I mentioned, we do have a blog up now as it relates to the interaction of Title VII and the use of AI in the workplace. So if you are interested, please go ahead and check that out. And if you do have any questions or something does come up after today's webinar, don't hesitate to reach out to Darius or myself. This is something that we both enjoy talking about and brainstorming about, and would be more than happy to discuss any of the topics today in greater detail, or, you know, help you work with your organization to develop an AI policy. But we want to thank you so much for joining today's webinar and wish you all a happy holiday.